My address is a little bit more boring. It's more steered towards lawyers in the room, and I don't have any slides, so you'll have to listen. There are two qualifications to that. The first is that I'll make available a copy or a permutation of this paper to the Attorney General's office. So if you'd like a copy, perhaps just email Priscilla or somebody at the AG's office and they'll provide a copy to you, or it can be put up electronically, I don't mind. And the second caveat is that if anyone has any questions, please feel free to ask. Otherwise, if you want to ask at the end, that's fine, and I'll be here afterwards. So if you want to ask a question directly, you're more than welcome to do so. And come up and say hello to me. Take a business card. If it's not for you, it's for me. It makes me feel important. And I bought a bundle of them. So try and come along and say hello and ask me a question, hopefully one that I can answer. And if I can't, I'll do the usual lawyer response and say, oh, it depends on the facts. Right, if we turn then to the topic at hand, a cursory reading of the operative provisions of the 2017 PPSA here in Fiji confirms the submission made to the Parliamentary Standing Committee by the Acting Governor on 2 August, before this Act was introduced, that the Fiji legislation is close in structure and form to the New Zealand Act of '99 and the Papua New Guinea Act of 2011. That's quite appropriate given the similarities in the economic structure. That being said, and putting the drafting aspects to one side, the principles and rationales from a legal perspective which underpin legislation of this nature is consistent amongst jurisdictions which have enacted a type of PPSA around the world. So this all started from Article 9 in the United States in the 1950s, and the difficulty with implementing US legislation is, one, it's almost impossible to read. I still don't know how to read it properly. But when you move from the US to the Canadian provinces, it becomes a little bit more plain English, and then you follow it through to New Zealand, and again it becomes a little bit easier to understand. And then I don't know what happened in Australia, but it went from something like 120 provisions to 340 provisions. So our Act is very chunky compared to the Fijian Act, and I must say, if I had to choose, I'd probably choose the Fijian Act because it's a lot better to understand. So you're quite lucky in that respect. Over today's address, I wish to speak to some of these fundamental concepts and look at some of the provisions which are of importance, particularly for the legal profession. And I must stress this, whilst the Act does have all of the objectives that the Governor mentioned, a lot of the technical aspects fall to the lawyers. Secured parties who play in this space are often entirely ignorant to the existence of the Act. They don't comply with its requirements, not because of any malintention or acquiescence, but rather because they simply don't know it exists. And the difficulty is that the Act is quite unforgiving. If you don't comply with the Act and you have a secured transaction, then it allows other people who also take a security in that same collateral to trump you. Or if, heaven forbid, the debtor enters insolvency, can't pay its debts, it goes into liquidation, then you may lose your security altogether. When I say you, I mean your clients. Often clients are very difficult creatures. They don't like to spend money up front to learn new things. They think that lawyers are out to make money, and yes, we are. But we're also there to help, and they won't come along and say, here's X dollars, please teach me about this new Act. They'll say, why do I need to know about it? And you'll need to have an answer pretty quickly, I would have thought. And the reason is because if they provide assets or take security over collateral and spend all this money drafting fancy, sophisticated contracts and then do not perfect under the legislation, it's as though they never drafted that contract in the first place. So really, the education onus is on the accounting profession and the legal profession to try and encourage stakeholders, particularly in the industries mentioned by the Governor, the livestock industry, the agricultural industry, the construction industry, to try and come to grips with this legislation and comply. And once these systems have been developed to comply with the legislation, well, to some extent, the operation is rinse and repeat. Once you know how to perform a registration, tailoring it for the specific transaction in question, you know how to engage with the register, and you have some comfort that comes from the system. But the period of transition, to give you a comparison, in Australia was 2 years, and I'm still getting cases noting that the PPSA commenced in Australia in 2012 because there was a lot of migration of data that had to occur in the Australian economic landscape. There are still problems. We're at the end of 2017, and I must say I have a pretty good practice out of PPSA problems over in New South Wales, and I've gone around Australia to deal with cases not just from foreign entities who take security over Australian assets, but from domestic entities and sometimes fairly sophisticated institutions, senior banks who get this wrong. So there's no shame in messing up the logistics of a registration. Your client should be fulsome and forthright with their factual analysis, and you should be armed to assist them. All right, so what is the centrality? Well, we've heard from the Governor that the PPS registry, or the Personal Property Security Registry, is central to the Act. There are a number of ways that one can perfect, and the term is perfect under the legislation, a security interest, but the most common in Australia, and indeed amongst the Canadian provinces and the experience abroad, is to register. So when one enters into a security agreement, the onus is on the secured party to then lodge what is called a notice under the Fijian Act on the Personal Property Securities Registry. And that notice provides particulars concerning what the security agreement says, and anybody who comes along and does a search over that particular debtor or grantor should be able to find, if you've done it correctly, notice of your security. That's not the same as uploading the secured document itself. Under other regimes, not the PPS regime, such as the Torrens system in Australia for land dealings, or the Register of Company Charges with ASIC in Australia, one used to have to upload the secured document. So when you've created the loan and it says, I hereby take security over X, that's a document, parties sign, that document gets uploaded onto the registry. That's not what occurs under the PPS. Right? What occurs is the lodging of a separate document through the registry, and usually it's not even a document, it's a web interface. It's a portal which you enter particulars. I'm a barrister, I don't ever enter particulars, but I get my solicitors to enter particulars, and then I check them. One needs to know how to navigate the registry system, but again, once one has done it once or twice, the job can be largely outsourced to a more junior colleague, because it's data entry, in essence. You're entering data, and you just have to make sure what goes into the system is correct. Because if you're not providing the correct details such that anybody performing a search can't find the interest, well, it's as though you've never registered in the first place, and the consequences can be quite severe. So what are these consequences? I've said that the consequences can be catastrophic. Well, what are they? A secured party who fails to perfect a security interest over personal property, one, subjects their security interest to other security interests which may be taken and which are perfected. So the example is this. Say your client provides finance to a particular debtor. They take security at time zero. They don't register because they have no idea that this act exists, which is quite common, especially over the early stages. Sometime down the track, this person or debtor needs to acquire new finance. They've spent the money, they want more money. They go off to a separate financier, a different bank, and the bank does a search of the registry, sees no encumbrance because the first party didn't register anything, and says, oh, you've got all these assets. Yeah, sure, you've got motor vehicles, got some inventory. I'm willing to provide you X dollars in finance. Unfortunately, sometime thereafter, party B, the second financier, then registers correctly. Somewhere down the line, the debtor's business fails, they can't pay anyone back, and party A says, well, I want to access all of the assets. And party B says, well, that's fantastic, thanks for that. I want to access all of the assets. So you've got a situation where you've got effectively two innocent parties, two financiers who have both tried to do the right thing. They're both out of pocket, they've both lent money, except only one of them is going to get the property. And it's party B, irrespective of the fact that party A exists. And even if party B knew party A existed, knowledge is not sufficient. It's what appears on the central registry. That's where the line in the sand is drawn, okay? It's all about the central registry. And it does not even matter about timing. The fact that one came before or after may be significant if the interests are the same. If they're both registered, well, which one came first? That's the question. But if one is registered and one isn't, the registered wins as a matter of law, right? Section 30 of the Fijian PPSA is consistent with that rationale. And again, you don't need to make a note of this because I'll provide my note. But if you want to make a note, Section 30 is the relevant section. And subsection 1, subsection little a, provides that a perfected security interest has priority over any other unperfected security interest in the same collateral. It's pretty clear legislative intent. Subsection 1b provides that the order of perfection determines who prevails between the two secured parties. And it's the perfection step which is critical, not necessarily when the agreement was entered. That's a change from other systems, and it's worth emphasising. So that's one. Your secured party may lose against another secured party. But what if there is no other secured party? Well, one still wants to have a perfected security, because property which is perfected also prevents a third party, not a financier, but someone completely independent, from acquiring an interest or buying one of the assets that are encumbered, free from the security interest. So say, for example, the collateral in question is a motor vehicle, it's a car. Your client, the financier, takes a security interest over that car and registers in accordance with the strictures of the legislation. Well, any third party who comes along and tries to buy that car, who performs a proper search, will see the encumbrance and will ask a few further questions and maybe say, well, instead of me paying the price to you, why don't I pay out your financier? So your client will end up getting what it bargained for. It'll get the money. If your client's interest doesn't appear on the register in the appropriate way, and the debtor absconds with the purchase price of the vehicle, well, the bank is left with two options. They can sue the debtor, and good luck, because if they've done this, they'll probably be overseas doing something else. You may be able to find them. Or they can go after the purchaser and say, excuse me, that's actually a vehicle which is encumbered to me, but you won't prevail because you didn't comply with the legislation. The third-party purchaser will be able to take free from your interest, and so they should, because they've done everything diligent that they could do. They performed all the necessary searches. And indeed, your client, unfortunately, and if they asked you to prepare the secure documents, you will be in a little bit of trouble. That's the difficulty. A lot of the time, secured parties who do recognise the difficulties here outsource the function to lawyers. They say, this is all too technical, let the lawyers do it. Don't mess it up. If you don't know what you're doing, give me a call, read the legislation, look at it quite closely, because the number of times I get involved in cases, sometimes it's for the client, sometimes it's for the lawyer who's messed up. The banking team has messed up. They've put a 0 instead of an O, a 1 instead of an L. You chuckle, it's happened many, many times. And sometimes you don't hear about it because the lawyer just sort of, oh yes, under the carpet with that one. But sometimes it doesn't work. The debtor goes under a few weeks later, and the client says, oh, well, I'm all right, I'm secured. The brief comes to me with all of these searches of the PPSR, and all of a sudden the client's interest doesn't appear anywhere, and by that stage it's all too late. Once the debtor has gone under and some liquidator has been appointed, or some third party is in control of the company, or a trustee has been appointed to a bankrupt estate, one doesn't get to come along after the event and try and right the wrong. That's the difficulty. The questions of priority crystallise upon the default event. They don't crystallise at some later stage. So by the time the brief comes to me, I say, thanks for that, I'm going to charge you a nice amount of money to consider your position. No prospects. You're not going to get this asset out. The best you can hope for is to do a deal for cents on the dollar, which is the very thing you were trying to bargain out of by taking security in the first place. You should have just taken the higher interest on an unsecured basis. So it's not just secured party friendly. It is secured party friendly when the secured party complies and understands the system, but it can be very unforgiving to a secured party who proverbially buries its head in the sand and says, well, this is all just legal mumbo jumbo, I don't want to hear about this. All right? So they're really the three difficulties. So you've got a priority contest with other secured parties. The perfected interest prevails against unperfected interest, so you should register is the short point. And there's other methods of perfection, but because registration is so central, I'm going to focus on that for the purpose of today. You should also register because you want to prevent third parties from buying the asset free from your interest. So you're not just protected against other secured parties, but you're really protected against the world at large. And 3, you're also protected against insolvency practitioners or the court who can recoup these assets upon an insolvency event or a systemic default by the debtor across the board. All right, so hopefully by now we're all terrified and we all sort of understand, oh yes, we've got to work out how to comply with the system. You're going to be refreshing the Reserve's website every day to see if you can navigate the PPSR, and indeed there'll be some external third parties, some computer technicians who come along and try and sell you these software packages. Oh, look how easy it is, you can just put in the data here. Just be careful with those. Sometimes they're helpful and sometimes It's a bit of smokes and mirrors. It makes it all too easy and you've missed out on certain pieces of data, which has occurred in Australia. And the best thing to do is navigate the official government resources first, and then if you find the convenient way of dealing with this, sure, whatever's convenient for you, but just make sure you understand at a high level what you're doing before you go ahead and scurry off to outsource the function to some IT person. All right, so how do we perfect? Well, under the law as it applied prior to the implementation of the Fijian PPSA, a secured party could take a security interest over personal property as opposed to land only in certain circumstances, and if they wanted to do that, they would be required to complete a bill of sale and physically register that bill at the titles office, which could be quite a cumbersome process. It was limited by trading hours and it was something which was relatively more slow. The PPSA, as the Governor's mentioned, creates a virtual filing office which replaces a physical titles office with an online registry or database, which can be accessed at any time subject to the management and maintenance of the registry itself and under the control of the registrar. Now in Australia, the system is pretty much available in my experience 24/7. It's always up except on some Thursday of the month where there's a circular which says it'll be down for an hour between here and here, and it took forever to develop the system because there was a lot of migration which needed to occur in the Australian context. But once the system was ready, it was ready, and it's been operating fairly smoothly ever since. So not only is this more convenient for secured parties and searchers and likely quicker to access, but it is also much more consistent in terms of its uptime, which is of great advantage, noting that foreign participants can also take security over domestic debtors, and they may not necessarily be operating on Fiji's time zone, so it also improves credit from foreign sources. The main difficulty for stakeholders who are not otherwise familiar with online systems of registration, as I've sought to allude to, is really their education, training, and the development of internal processes and protocols for properly recognising, one, when they take security in the first place, and two, how to deal with that, how to perfect once they have taken security. Fortunately for the Fijian participants, the Fijian PPSA appears to be simpler in its legal requirements than the Australian counterpart. Section 70 of the Fijian PPSA requires that an initial notice provides for the following 5 elements: the identity of the debtor, a physical address for the debtor, the identity of the secured party, a physical address for the secured party, and a description of the collateral or personal property covered by the notice. They're the 5 critical features to an initial notice. It does not appear on the face of the legislation, and I may be reading it far too simply when I briefly reviewed it, but it doesn't appear as though there are any more specific requirements as part of the Fijian model. Indeed, many, if not all, of the prescribed requirements are likely to derive from the secured contract itself. If you look at the security agreement, you're likely to find the name of the debtor, an address for service on the debtor, the same for the secured party, and a description of what it is that the security is being taken over. So what that does is it prevents secured parties from having to go off and do all of this extra due diligence in order to make what may sometimes be a fairly routine secured transaction. In Australia, there are some more prescribed requirements when you're identifying, and I only say this briefly because it doesn't really matter for the purposes of the Fijian legislation, but when you're looking to identify the grantor, there's specific indicia. For a company, you can't include the Australian business number, which is a tax number issued by the Australian Taxation Office. An ABN registration is ineffective. It has to be the Australian company number, for example. And you can't even include just the name. So it's very, very prescriptive. And that's because there are so many companies that one needs to be precise, and reference to a number is more precise than reference to a name. An initial notice is effective at law in Fiji unless it contains a defect, irregularity, omission, or error which can be characterised as seriously misleading. And the term used by the statute is seriously misleading. As to what constitutes a seriously misleading defect, it is helpful that that particular term has also been used by other PPS regimes. So if you want to have a look at, for the lawyers in the room, for some of the case law from the foreign jurisprudences, including Australia, you will get an understanding of what foreign courts have interpreted to mean seriously misleading. Amongst the Canadian provinces, for example, a seriously misleading defect has been held to be one which would prevent a reasonable third-party searcher who performs a search under the PPSA from finding the relevant notice. So it's a defect which really goes to the heart of the relevant registration. To my mind, errors in identifying the debtor or grantor would fall into this category. So if you've taken a security interest over party A, but you've registered it over party B, whenever somebody comes along and does a proper search for party A, they won't find your interest. Well, that's a seriously misleading defect. The person performing the search has been seriously misled because they won't be able to ever find the data at no fault of their own. It's an error on the part of the registering secured party. In the Australian jurisprudence, the test for whether or not something is seriously misleading is an objective one. When you go to the court to argue that something is seriously misleading, for example, you don't have to have evidence that anyone was actually seriously misled. All you have to do is say at an objective level, here's how you would perform a search, it wouldn't reveal the data, therefore it's a seriously misleading defect on an objective standard. This is the same with the Fijian PPSA, which under section 75 subsection 4 provides that the test is objective. No one has to be seriously misled. In the New South Wales Supreme Court case, Future Revelations and Medica Radiology, a defect in the secured party's details, not the grantor's details or the debtor's details, but the secured party, was held not to be a seriously misleading defect because everyone always searches for the grantor. They don't care who's taking the security so much. They really care who's proffering the security because it's their property that is the subject of the encumbrance. That's not to say that you can just ignore the secured party details. There has to be some way of identifying whose security it is. In that case, the secured party was identified by ABN, as I said earlier, Australian business number, not ACN. So you could still work out who the secured party was. It just wasn't strictly in accordance with the statute. So if you're going to make a mistake, this is the carve out for the law. If you're going to make a mistake, don't mess up the grantor details. Don't mess up the debtor's details. That has to be 100% bulletproof. The secured party's details have to be sort of right. That's the lesson from the New South Wales Authority. It is clear from these statutory provisions that secured parties need to strongly consider the development of internal protocols or systems for lodging initial notices on the registry. And as the Governor has said, the time period is 6 months from the going live of the registry. So it's not forever. Secured parties don't have till whenever they feel like to come to grips with the legislation. And in my view, of course I'm going to say this as a lawyer, sooner is better. If you can go out there and speak to your clients and say, look, you're in the business of doing this, you supply goods or you provide finance or you're in a hire industry, you may want to think about this, and it's often useful to generate some internal bulletins and send them out as circulars to the clients. They get a sense of what's coming and they turn their mind to thinking about how they're going to attend to the registration process. And if they've got multiple different products, they may need to think about registering those different products in different ways to ensure that what is put onto the registry is accurate and it reflects what's in the contract. Because again, what you don't want is to have this process where the client goes off and registers a bunch of things, but of course all of them have the same error and the court finds on one instance that that's seriously misleading. Well, all of a sudden the whole book is exposed because they're all registered in the exact same way, which has happened in Australia. All right, does anybody have any questions about perfection, registering? Everyone's an expert? I'll never get a call? Going once, going twice? Yes? Do you want to do questions at the end? Okay, question at the end. Pause that question, write it down, come back to questions. Sorry. Should have actually asked that. I just said ask questions, so just yell at me, yeah. All right, I'm going to now turn to a specific type of security interest called the purchase money security interest. And the reason why I find this very interesting, and you will find it interesting as lawyers, is because it's a creature or a concept which arises only under the statute. There is no common law equivalent of this particular type of interest. And it's got a funny name because if you take the acronym Purchase Money Security Interest, PMSI, I've had a number of cases where the court reporter taking down the transcript has said, what did you just say? And the word is PIMSI. It's called a PIMSI. And the court reporter goes, what's a PIMSI? It's not a part of English. I said, just PMSI, copy paste, that's what it is. And the judges understand what this is. So take the PIMSI. Right, what is a PIMSI? A PIMSI is a specific type of security interest which facilitates and promotes further business when a debtor has already encumbered all of their assets in favour of one secured party. What am I talking about? Well, in Australia and perhaps also in Fiji, it's very common for one financier to provide a large overdraft facility and take security over everything. It's called the sell your soul charge. Right? Everything. They take a security interest. In Australia, it used to be called the fixed and floating charge. Is anybody familiar with that, the concept of a fixed and floating charge? That's gone under the PPS. Everything is a security interest. It doesn't have to be fixed and floating. All security interests are fixed. Under the PPS, they're referred to as all present and after acquired personal property security interest. It's a bit of a mouthful, so we call them all PAPs, right? All present and after acquired personal property. That means everything today and everything that will ever come in. That's a fairly restrictive security, because as soon as the debtor comes into any asset, that charge automatically applies to that asset. So you'd say to yourself, all right, if I'm going to do business with this particular debtor and I'm going to supply this debtor with assets, they're a retailer, I'm a wholesaler, I'm going to supply widgets, scaffolding, stock, whatever it is. You do a search of the PPS registry and you work out that there is an all PAP, an all assets charge. Why would you ever supply your asset? They've got a first ranking security, which is perfected. The best you can do is go onto the registry and perfect your interest, which will always be later in time, so you'll always lose. You might as well do it. So instead of saying, okay, 30-day trade terms, you say cash on delivery, and if you don't pay, I come along and I seize. It's a very draconian, it's the exact opposite of what this Act is trying to achieve, which is to stimulate further economic development. So the Act says, all right, we'll create a separate concept called a purchase money security interest. So if your client provides the purchase monies to acquire a very specific asset, or they provide the very asset itself, okay? I'm either providing money to buy the widgets, or I'm providing the widgets. Well, that specific type of security is deemed by the Act to constitute a PIMSI, and in a priority context, provided the PIMSI is registered appropriately, a PIMSI defeats a general security, okay? Irrespective of when the PIMSI arose. So you can have an all-PAP from the very beginning, sometime thereafter the widgets are supplied, provided the PIMSI is registered appropriately and recorded on the registry in accordance with law, that PIMSI prevails against the all-PAP holder. So the secondary party, the party who's supplying, doesn't get stung by the perfect first regime. Okay, that must be right, because otherwise you just never supply. Right? The only way you could possibly supply is to enter into a deed of subordination with the primary lender to say, even though I've got first ranking priority, I'm going to contract out for the benefit of you, which is very cumbersome. Yeah, that whole process would just be completely inconsistent with the legislative regime. All right? The proviso and the kicker is that the PIMSI holder has to register within 7 days of creating the PIMSI. If you don't register within 7 days, that doesn't necessarily mean you don't have a security interest, but what it does mean is that you won't have PIMSI priority. Okay? You'll just have general priority, and as I just said, having general priority isn't good enough, because the all-PAP holder is going to beat you. So you really, again, this laissez-faire sort of, oh yes, we'll get to it, we'll learn about PPS. Now, you've got to learn about it now, because the difficulty is if you don't and your clients are supplying stock, they're in the business of selling inventory, for example, they may be stung by this if they're doing it on trade credit terms, which is terribly common, at least in Australia. Hardly any supplier with a retail credit account pays cash on delivery. All right? So the kicker here is that it is not just for the big banks and the finance industry to, when they're providing loans, it's also for suppliers. If they're supplying assets and retaining title to those assets, have you heard of that, retention of title type arrangements? Well, if they're doing that, they are creating a security, because they're having recourse to the personal property if they don't get paid. That's the very same thing as creating a loan. Providing finance and taking property if you don't get paid. It's the same for the supplier. And the Act treats those two interests identically. The only way that the retention of title holder prevails under this regime is by taking the PIMSI and registering it as such. Now, I'm not sure if the Fijian registry has enough functionality. Under the Australian system, there's actually a question. It says, are you taking a PIMSI? And you tick the box or you don't tick the box. For all the lawyers in the room who know anything about priority, there's this almost primal instinct to just always tick the box. You always want to give your client the highest ranking priority. Yes, of course, PIMSI. The difficulty is if you do that and it's not a PIMSI, not only do you not get the benefit of the PIMSI perfection, but the entire registration is arguably seriously misleading. And indeed in Australia, whether it's seriously misleading or not, that sort of defect renders the whole registration ineffective. So you're not just putting your client back in the ordinary security position, you're putting them in the position as though they're unsecured, and then the client's going to contact law cover or whoever your insurer is and say, my lawyer stuffed this up, this isn't my problem, it's my lawyer's problem, with respect, and then you're going to have some sort of lawsuit on your hands. So just be careful about how you're characterising the security, have a good understanding of what a PIMSI is, register as a PIMSI where appropriate, and if you're not sure, and this is what I would advise for the interim, don't just register a PIMSI. Register the exact same security interest as a non-PIMSI as well. Because if one fails, one registration says nothing about the validity of another registration. Okay? Remember, this is just a notice-based system of registration, so you can provide multiple notices. One is not seriously misleading because arguably it falls into one category or the other. Okay? So just bear in mind the options that are available to you and your clients. All right, I'm running out of time, but I'll persevere. I'll persevere. Those are the two main concepts that I want to speak about. It's the idea, and the reason why I always speak about these concepts when a new PPS regime is introduced, as was the case in Australia, is because they're the two fundamental changes which really occur, the registration process and recognising the quality of the security. So now I'll speak briefly, and I should speak very briefly given the time, about my experience with the PPSA in Australia and some issues that have arisen in Australia which commonly centre around properly characterising the underlying security interest. There's still a large problem because it is factually specific about whether or not the transaction itself is a security interest or not. In a conventional loan sense, when the bank provides a loan and then you give them a mortgage or you create an encumbrance in favour of property, that's a very vanilla transaction. That is clearly a security interest. There's no problem there, all right? It becomes a little bit more difficult when one doesn't take a conventional bank loan, but say, for instance, the contract provides an option to purchase personal properties, shares in a company or something somewhere down the track. Well, is that a security interest? You don't know. You may not know. It may turn on what appears in the contract. What about a short-term lease, something which is for 3 months, a short-term hire arrangement, which then extends on a month-to-month basis? So instead of them entering a new contract, they just say, look, pay me the same rates on a month-to-month basis. Well, under this Act, leases which go for more than 1 year are deemed to be security interests. So is that particular arrangement a security interest because it has the potential to go for more than a year? And if so, when does it become a security interest? Is it at the outset of the transaction or some later time? As an example. And that question is important, of course, because as the lessor is the parties providing the asset, they are in the position of a PIMSI holder. They're the ones providing the very collateral, so they would want to register a PIMSI. But you've only got 7 days to register the PIMSI. So if you don't know when the security interest has arisen, how could you possibly properly register the PIMSI? There's no answer to this question. This is a hypothetical. There's no answer to this question. It's the type of issue that the legal profession, who understands this regime, needs to turn its mind to and adopt some prudent processes for managing client expectations about what sort of interest they're going to take. Is it the position that they collapse the 3-month lease, repossess the goods, and then reissue the goods as a way of dealing with this conundrum? I can tell you in Australia these issues have arisen. The regime over there is more complicated in terms of the PIMSI provisions, and there are different timing requirements, but the exact same considerations arise. What about for a sublease scenario? So you act for the primary lessor, they lease assets to party A, they're the lessee, that party then on-leases the assets. Well, you've only registered against party B. You don't have a registration against party C, so what happens if they both go into administration or insolvency? You're arguably unperfected as against party C. Now, you can do all you like to tell party B to register, but it's unsatisfactory for your client to be in a position where they're relying on the registration of somebody else. I've had particular clients where I ask them about the registration process and they say, oh, all of it's automated. I said, what do you mean? So we've developed a computer program which analyses the contract and picks out the relevant data and registers. I said, oh, that's fascinating, that's great. Who puts the data into the contract in the first place? Oh, it's the dealer who does the contract down the line. I said, so it's not even an agent from your business. It's a dealer, some external dealer. What happens if they mess it up? What do you mean? What happens if they get it wrong? You're the one who's secured. Oh, well, we haven't considered that. Well, you might want to consider it. Credit in Australia at the moment is very good, but it's not going to be good forever. You may want to turn your mind to that and turn your mind to it pretty quickly. Oh, can we do that? Yes, you can. Yes, you're the financier. You can do that. Anyway, you'll remember my words when you'll get financiers who come along to you after they've registered 1,000 of these, and then they go, oh, we've got a letter from a liquidator here that one of these is bad. And you go, oh, well, let me have a look at that. Oh, yeah, it looks like you might have some problems. And then you go, can I have a look at the rest of your registration? And they've all got the same. It's a big, big problem. Makes a lot of money for lawyers. Wonderful. It's bread and butter, the cornerstone of the legal profession, I must say, errors of clients. And they're going to, and there's no win. I mean, you don't provide a win. You say, look, it's going to cost you X dollars to fix this up, and then they get upset with you and, expletive. They get very, catatonically distraught. You say, well, just lose your whole book. Don't worry about it. Everything that you've got out there, write it off as a loss. Well, I can't do that. Well, quite. So stop whinging and get on with it. The whole thing could have been avoided when we're all sitting in this room at this level. Before this whole thing goes live, if one goes out there and tries to somehow convince your client to turn their mind to this before the event, then you don't have this catatonic problem which arises afterwards. I've put in the paper a number of cases where I've appeared to try and fix, it's called the fix your book type application, where you look at the originating process or the summons filed with the court, and it lists 1,000 registrations which require some amendment. And the court just looks at me and says, are you serious? We're going to go through... So we don't have to go through 1,000. You're one of my solicitors have prepared a table which summarises the errors and you can deal with it. But the cost of that exercise, to gear up, re-registering 1,000 interests and all the lawyer time spent, look, I mean, it's delicious for us, absolutely delicious, I must say. But for the client, it's an extreme waste of resources that they could have avoided if they just spent a fraction of that money, 1/100th of those funds in the first place, all right? So I said this in Australia, the annotated book came out before the Act went live, right? So I've been pumping this out and developing a practice around this for a very long time. And many clients took it on board and they've got fairly sophisticated PPSR compliance regimes. Some haven't, and one way or another they'll call me at some stage. I'm not too threatened by this. As a member of the independent private bar in Australia, I can take instructions from liquidators, purchasers, creditors, so we just get the cream. Anybody who comes to me can have some sort of question answered. So that's the same for the legal profession here, but at this stage where there isn't any litigation because the Act is not live, we really have to have quite a creditor focus to try and promote that education process amongst creditors. And the advice I often give to my clients in that respect is if they're unsure about their position, the default should be to register, to assume the Act applies and comply with it. Okay? So if you've got a transaction, a short-term lease, which could turn into a long-term lease, but it doesn't necessarily have to turn into a long-term lease, just register. Tell your client to register, because the cost of doing that is an administrative fee, paying to put something onto the PPS registry. The cost of not doing it and the Act applying means you could lose the asset. The client could lose the asset. All right. The other thing, of course, is in the case of the PIMSI, as I've already stated, if you're unsure about whether it is a PIMSI, register it as a PIMSI and register it as a non-PIMSI, okay? When the third-party searcher does a search and sees both interests and they call you and say, what's this, why are there two? Provide them with a copy of the security agreement and say, this is the nature of the security interest that has been taken, and then nobody's misled, all right? There's a very practical and commercial way around it, because that searcher is looking to do business with this debtor. If they're trying to take an interest in this asset that your client has a first-ranking priority over, there's going to be no fight if they just don't do business in the first place. It's when you let things go and they don't take notice, they take an interest, and then somewhere down the line everything blows up. That's when it's a problem. That's when they've already spent money, they've already invested their interest, and they will fight you and they will fight your client about the particular interests. All right, I do need to stop. I'm getting very happy about the PPSA. My concluding remarks would be the one aspect of the Fijian regime which is more punitive or more strong than the Australian regime. The Australians have all of these technical provisions which sting secured parties in particular ways. The annotated PPS is some 800-page monster of a book. I didn't bring it. It's too heavy. It wouldn't fit in my luggage. The Fijians have a specific provision, and it's Section 112, which creates a very coercive penalty regime if one actively tries to mislead what appears on the PPSR, there are prison sentences associated with doing this sort of a thing. Don't do that. Always have a cogent basis for registering your financing statements. Usually a reasonable belief by a competent legal practitioner is enough to get over the line, but don't just register things willy-nilly. Initially, when this act came out, I thought about taking the good path or the bad path. The bad path is to go along to all the major trademarks and register a security interest over all of them, because the cost of removing that, I'm being facetious, don't take this to heart. The cost of them going off and taking me to court to remove this would be greater than them just paying me out, and I'd just remove it voluntarily. So set up a sort of a negative business. That's, you know, amongst being illegal and something you shouldn't do, is probably something which will land you in jail. Let me tell you, in Fiji, it would definitely land you in jail. There's no equivocation about it. Don't do that. Just do what your client instructs you to do, and make sure you can give them competent legal advice concerning when and when they cannot take proper security. Thank you all for your patience and time. I'll take questions at the end.